today in court, I know a lot of people are super, wanting to know what happened. I can tell you it was definitely a fight. It was definitely an argument. I really don't like her attorney at all. Like, I don't like him. I think he's treated me poorly. He is not, he's just, to me, he's just a scoundrel. And that's just my opinion of the guy. I don't like him, and I feel like he doesn't mind doing unscrupulous things. But he likes to misinterpret what has been said. And it's just, he intentionally misinterprets the language to the court. And so there was a cut and paste issue on there. Long story short is I argued basically substantial truthfulness to the counterclaims. I don't know if it's an argument that will win. I couldn't gauge the judge one way or another. Typically the judge always goes with the attorney more so than the pro se litigant. So I am, kind of up against that battle and that hurdle with the case of Miss Turner. And so I think I argued well. I don't know, I probably, every time I go in here, I hope I do good, right? But it just really depends. I think I was more prepared this time with my statements and my oral arguments, even though I said arguments, it's like, we're here for oral arguments. That's what it's called, oral arguments. And every time I said arguments, he tried to play it off like, this is a pleading stage, this isn't for arguments. They're oral arguments. We're here for oral arguments. When the judge was talking to us on the 21st, he said, I will listen to your oral arguments on the matter. So every time I didn't say oral arguments, he's like, well, she's saying arguments, Your Honor, and this is like, whatever. I really don't care about him. The bottom line is they're trying to open me up to discovery when the statements were substantially true. And there's a substantially truthful standard in the state of Illinois that I'm kind of standing on with Ms. Turner's counterclaims. So did I win that argument? I really don't know. We won't know for a while. He didn't tell us. What I like about this judge is he at least reads through the stuff. And that's all I can ask for, is that he reads through the stuff. And that and for whatever reason, I was reading the stuff right in front of my face, and they're saying, and opposing counsel's like, there's no law for that. I'm like, I'm reading it right here, and apparently I said 351 instead of 359. So whatever, I ended up getting that clarified. But I'm not an attorney. I'm a pro se litigant, and that's just how I've got to be able to work full time, and I've got to be able to do my job, as well as litigate this case. And so, he brought up, which is kind of funny because I talk about how his client is constantly watching me, having her minions watch me. They've got me under surveillance online and offline, and then they go and prove it even more by literally timing how much I work. Like, I work. There's no ifs, ands, or buts. I work, and I work online. So I did give arguments, the substantially truth standard argument on the statements that were made. I don't know how the judge will entertain these arguments. I'm hopeful that he will see it my way because, I'm having to defend myself against mostly truthful statements. It just doesn't seem right that they're going to open me up to discovery on things that aren't defaming. She was arrested for selling alcohol to minors, and she was arrested for, a drug bust, a house raid in a freaking, in what appears to be a trap house. After a 2-year investigation, they got her with intent to sell Coca-Cola, right? So substantially truth argument might work. Not sure, we have to wait to see what the judge actually orders, but he is going to review everything.
Now, Paul, ridiculous as it may seem to have to explain this to a 6-year-old child, but I do need your help.
Go ahead.
I was expecting a very important spell in the mail from my teacher, Professor Emilius Brown, and it hasn't come.
What's that got to do with my knob?